All right. Hello, bonjour. Good afternoon, everybody. My name is Eric Chaput, Business Advisor at the World Trade Centre Winnipeg. I would like to begin by respectfully acknowledging that this webinar is coming to you from Treaty 1 territory, traditional territory of the Anishinaabe, Cree, Oji Cree, Dakota, and Dene people, and on the national homeland of the Red River Métis. Okay, so before we start, a few housekeeping information before we start. Please send all webinar questions directly through the chat box at the top of your screen, and Chantal and Michelle will try their best to answer as many questions during the Q&A session toward the end of the webinar. For all logistical questions, please send directly to the chat box and I will answer your question as soon as possible. You will also receive the PDF copy of the presentation and recording of the presentation within the next week. So now it is time to start the webinar. I would like to introduce you to Chantal Smith, currently working with the Employment Standard as an intake officer, experienced investigator with in-depth knowledge of various pieces of labor legislation, includes the Employment Standard Code, Employment Standard Regulation, Construction Industry Wages Act, Remembrance Day Act, and various other pieces of provincial legislation. Before starting at the Employment Standard branch, Chantal worked at North End Community Renewal Corporation, where she led an eviction prevention and housing preservation program, working with tenants, landlord, and community agencies to prevent eviction and homelessness. When she's busy not running her kids to various activities, Chantal can be found kayaking and hiking with her dog in the woods. We also have Michelle Brennan, which joined the Employment Standard earlier this year as a bilingual intake officer. Prior to joining our branch, Michelle spent 17 years working in healthcare, with her most recent position being in quality assurance and regulatory affairs and lab supervision. In these roles, Michelle developed strong communication, problem solving, and investigation skills. Further, Michelle has completed Lean Six Sigma and Green Belt training and has recently completed a certification in human resource management. Outside of work, Michelle enjoys spending time with her family and friends, reading and learning new things. All right, so welcome Michelle and Chantal, and let's get this webinar started.
Hi, Eric. Thanks for that introduction. So I'm Chantal, my colleague Michelle here. Hopefully, we will address some of the questions you might have about employment standards. And as Eric mentioned, we'll have time at the end to get into anything that's not covered or any more specific sort of questions you may have. So as you see on the slide, we're going to be providing an overview of employment standards and hopefully you'll find some useful information there. Okay. So some of the more common topics that we'll go over are you'll see on the slide here. Try to touch on, the issues that we tend to field the most questions on our general inquiry line about, things that probably will have, most relevance to the audience today. And again, like if there's anything that's not mentioned, please park it in the chat, and we'll definitely get to that toward the end of the presentation. So just to talk a little bit about employment standards, I think I really want to stress that we are a neutral third party at Employment Standards. We don't advocate for employee or employer. So if you have questions, don't hesitate to call. We want to be a resource to you. We want to be able to help you with your concerns, your issues, and really provide a strong sense of what your obligations under the legislation are. To that end, we have a website that's available to you 24/7. And what's really fantastic that Michelle and I both love about the website is that it has a section for fact sheets that goes into fairly deep, in fairly good detail about most common employment topics. And that's available to you 24/7. And it breaks down the legislation in plain language, making it really easy to understand, really easy to share with employees, or vice versa, for employees to share with their employers. So that's a really underutilized resource. We just want to stress that. But if you have something more specific, we do have a general inquiry line available Monday through Friday, 8:30 to 4:30, that will provide general information to you. And I do want to stress that it is general information on the general inquiry line, because when we do an investigation at employment standards, when a claim is filed, as a neutral third party, we're going to reach out to both employee and employer and give each party an opportunity to share their story, provide information and evidence that supports their position on the claim that's been filed. So sometimes you might call the general inquiry line as an employer, asking questions about a particular issue. Maybe you're calling back the next day to get some more clarification. Maybe those answers you're getting are slightly different. And that's because it's going to depend on the information that's being provided by the caller, the questions that are being asked by the caller, and as well as the questions being asked by the investigating officer, or pardon me, the officer on the general inquiry line. So the person who will be taking your call is an officer with employment standards. They will be able to speak to the legislation, but again, it's just providing that general piece of information. So just understand that. But if you need a sort of a primer on the issue that might be at hand, definitely have a look at the fact sheet section on our website. So as I mentioned, we are a neutral third party. We don't advocate for employee or employer. Our role is really to help both parties understand what their rights and responsibilities are when it comes to employment standards legislation in Manitoba. Employment standards code is minimum standard, and it does applies to most employees. It doesn't cover every aspect of the employer relationship. And it also doesn't cover every employee. So if you are in a federally regulated industry, for example, trucking, we field some inquiries about truckers that cross provincial or international borders. That's a federally regulated industry. So we're going to refer those questions to the Canada Labour Program. And as well, if you're unionized, you have a collective bargaining agreement, and then the employment standards code would not apply in that situation. As I mentioned, employment standards code is minimum legislation. So it doesn't allow employees and employers to agree to work for less than the minimum standards. So the minimum standards in the code will always prevail.
Okay, I'm going to get us started with one of the more foundational elements under the Employment Standards Code, which is minimum wage. So as most of you likely know, Manitoba has a minimum wage rate, and that rate gets reviewed every October. So currently the minimum wage rate is $15.30. Things that you need to be aware of as employers is that while the minimum wage rate would apply to most of us under the code, there are always going to be some exceptions. So there are exceptions for construction workers and those who fall under apprenticeship agreements where there may be specified minimum wage rates for particular types of occupations. With minimum wage, it applies regardless of how you're paying your employee. So if you have an employee who's on salary or being paid by incentive or piecework, something like that, it still needs to average out to the minimum wage rate per hour. So that's something to be aware of. The other part that I wanted to make sure we touched on is that a common question that we sometimes get is about raises, as an example. So employees might believe that under the code they're entitled to a raise, but there is actually nothing under our legislation. So as employers, you can always offer to provide more than what is covered under the code. You also need to be aware that you cannot get an employee to work for less. So even if you entered into an employee-employer relationship with an individual and they agreed to work for $14 an hour, that is not permissible under the code. Everyone, regardless of their age, so young workers, regardless of how many hours they're working, full-time, part-time, everyone is entitled to minimum wage under the code. Thank you. So next topic is payment of wages. I would say that, Chantal, you can jump in if you disagree, but I would say 95% of our calls and 95% of our claims are all regarding issues related to the payment of wages. So as employers, some just basics to make sure that you're aware of. Under the legislation, employees must be paid at least 2 times a month, so semi-monthly. That also means that the longest pay period an employer could have would be 16 days. And wages must be paid within 10 business days of the end of a pay period. The exception would be 5 days in construction. And employers are not allowed to withhold an employee's pay. Now, with this piece, when we talk about the payment of wages, that also comes into play when there's been a termination. So if you have ended the employment of one of your staff, or if an employee has given their notice and reached their last day, everything that is owed to that individual must be paid to them within 10 business days if they don't work in construction, and within 5 calendar days if they are employed in construction. From the slide, you see that we do have a few pictures at the bottom. That's to highlight the ways that you can pay your employees. So under the legislation, Canadian currency is acceptable. You could use cash, provide a check, or a direct deposit. Those would all be acceptable ways to provide payment. Now, another thing I wanted to highlight just before we start,
Oh,
that's okay. No,
sorry,
that's
Michelle.
no problem at all. I wanted to just come back to this concept of, employee versus, or sorry, hourly versus monthly versus an annual salary. So of course, you as employers can provide your staff with monthly or annual salaries, but just want to make sure that there's no misunderstanding that, well, if I pay them monthly, I only pay them once a month. No, it's still, you take that monthly salary and you figure out whether you're paying it, weekly, bi-weekly, or semi-monthly. You have to make sure that you're doing that payment at least 2 times in the month. Thanks, Chantal. So this is an example of a pay statement. So one common question that we get on the GI line is that many employees are saying that they don't receive pay statements. And under our legislation, employers are required to provide pay statements when they pay wages. And the pay statement needs to cover certain basic information. So we're looking to see, as highlighted in this example, albeit with an hourly rate that is no longer reflecting minimum wage, they need to be able to see what is their regular wage rate, how many hours they're being paid that rate for, what is their overtime wage rate, and how many hours they're receiving pay for that category as well. And then they must also see all of the deductions that are being taken from their wages, as well as, pardon me, a reason for each deduction. So in this example, you see that it's clearly listed in the deduction section, income tax was X amount, health insurance was X amount. So to an employee, this is very easy to read and interpret and understand how much they earned grossly, how much was taken off, what was the reason for the deductions, and then understanding what their net pay is. You as the employer also need to ensure, nowadays, most people are getting electronic pay statements. So if you're emailing or you have your staff log in with an app, that's also acceptable. It's also good to make sure that staff, if they didn't have the ability to print at home, that you have that option available to them in the workplace as well. So as per our conversation on the previous slide, there are a number of types of categories of allowable deductions from employees' wages. So the first is all of your statutory deductions. So the income tax, EI, CPP, those are all allowable deductions. Employees should understand why those are being taken off. Another category is if you had a payroll error. So let's say you accidentally keyed in an overpayment, you can make that deduction in the next pay period when you've identified the error, and you've made the employee aware of that and that they know that that was a payroll error that they're correcting for. You can also recover for pay advances. So if you're entering into an agreement, the legislation doesn't get into the specifics, but if you're doing pay advances, we always recommend that you try to have something in writing so that it's very clear between both parties, the employer and the employee, how much is being advanced and what is the plan for that repayment so that there would be no misunderstandings. Third category of an allowable deduction is for court orders or garnishments. So if you have that situation in your workplace for an employee, then you are allowed to take those deductions from their wages. The core message takeaway for you is that any deductions that you are taking from your staff must be of a direct benefit to the employee. If you're finding yourself falling into a category that isn't listed here, then likely you're entering into the zone of potentially unauthorized deductions. If we go to the next slide,
Perfect.
thank you. So on this slide, we are talking about how even if you had an agreement between yourself as the employer and the employee for any of these situations listed here, broken, stolen, or damaged property, faulty or poor quality work, etc., you cannot deduct those amounts from the employee. That is not allowed under the Employment Standards Code. That would be considered an unauthorized deduction. We do recognize, of course, that for employers, this can be a frustrating situation. Hypothetical example, if you had someone using a ladder as part of their work and they damaged it or didn't keep it secure and it ended up being stolen. Obviously, that's very frustrating, but you can't take it out from the employee's wage. You would have to look at other forms of recourse, whether that might be through small claims court or another form of recourse. Okay, this is another common question that we get on the general inquiry line. And this is about the differences between dress codes and uniforms. So generally speaking, a dress code is not unique to an employer. So we might see an example in hospitality where an employer might ask the employee to wear all black. So black shirt, black bottoms, black shoes. That's a dress code. The employee has the ability to go and purchase those items of clothing from wherever they choose, at whatever price point they're comfortable with, and they can use that clothing outside of work. A uniform is something different. A uniform is generally unique clothing to the employer. Often you'll see that it's going to have a logo or something else, making it very specific to that business. And in that case, the uniform is the responsibility of the employer, and the employer cannot charge an employee for a uniform.
Thanks, Michelle. We're going to move on to the next topic. One thing that sort of comes to mind when you're talking about paying wages and deductions, the word transparency, I think, is really important, right? I mean, both from the perspective of the employer and the employee, if you have transparency about the payment of wages, about deductions, then you're less likely to have questions. You're less likely to have employees calling employment standards, potentially filing claims because they're not really sure how they're getting paid, what their hourly rate is, what the deductions are for. So as transparent as you can be, it definitely, I think, is helpful for both parties.
100% agree.
All right, thanks, Michelle. We'll talk a little bit now about ending employment. So when you're talking about ending employment in Manitoba, either party, employee or employer, either party can end employment at any time for any reason. They don't need a reason in Manitoba. Employment can just simply be ended. But what we concern ourselves with at Employment Standards is the notice period. So there are legislated notice periods based on an employee's length of service that must be respected. Again, Michelle had talked briefly earlier about when employment ends, all wages needing to be paid out within 10 days of termination. And that's, it doesn't matter if the employee or the employer ended employment, that time frame still applies. So making sure that you're getting those wages paid out, including any vacation that might be owed to the employee, any banked overtime that the employee hasn't used, those would all be considered due and payable within 10 days. Notice can take a couple of different forms. It can be a working notice where as the employer might say, hey, employee, I'm giving you notice today that your job is ending in 2 weeks. You're going to work out your shifts, and then the employment will end. That's called working notice. Maybe sometimes, though, there's a circumstance where employment has to end suddenly. And in that case, what we look at Employment Standards is wages in lieu of notice. That's often called severance pay. Legislation talks about wages in lieu of notice, but the notice periods apply to both the working notice and the wages in lieu of notice. So bring this up on the next slide here. Notice periods are pretty straightforward. One thing that I think Michelle will agree, we get a lot of phone calls about notice periods, talking about either probation periods or the 30-day threshold for when a notice period applies. Takeaway here is that a notice will apply once the employee has been employed for 30 days or more. So I think 29 days is the time frame that you really need to keep in mind as the employer if you're considering ending employment of a new employee. Once they've reached 30 days, then you're in a period where notice is required. And again, the slide will show you that depending on how long the person has been employed, that'll be the corresponding length of notice that's required, either working or wages in lieu of. It can also be a combination of working notice and wages in lieu of notice, but these would be your obligations under the Employment Standards Code.
I just want to highlight on one thing that you mentioned, Chantal, just about that question of probation. So we know that as employers, you can have your own policies. You just need to be aware that under the legislation, there is nothing specific allowing a longer probationary period. So the only time, as Chantal said, that no notice would be required is if that period of employment was 29 days or less.
Right, you bet. Yeah, probation period does not equate to a notice period.
Right.
The other thing that I want to bring up that we also get a fair number of calls on in the general inquiry line is regarding the concept of wrongful dismissal. So wrongful dismissal is a civil concept. That's not something that's in the Employment Standards Code, because as I mentioned at the beginning of this section, either party, employee or employer, can end employment at any time for any reason. If someone feels that they've been wrongfully dismissed, they may have recourse possibly through small claims or other legal action, but that's not something that employment standards would be investigating. Also just draws my attention to the fact we have a really great fact sheet on our website about this, Michelle. So if you have any questions or you'd like to take a peek at that, that's definitely a good fact sheet. So on the same sort of thread here with talking about termination, sometimes there's a little bit of confusion about termination and layoff. Termination, to be clear, is a permanent break in employment. This means the person is not coming back to work, that you're not having the employee return, and then there's notice does apply. However, if the person is being laid off, perhaps there's a slowdown, you're hoping that the employee can be returned to work. That's a temporary break in employment. There's no notice that's required. The key being once that person has been laid off for 8 consecutive weeks, under legislation, it's considered to be a termination. And then we would look at notice applying, either working notice or wages in lieu of notice. Alternatively, if a person is laid off for a total of 8 weeks in a 16-week block, they would also be considered to have been terminated. And again, notice would apply either working or wages in lieu of notice. Now, in the vast majority of cases, notice is going to apply when termination ends. There are some exceptions. We'll talk briefly about them here. So, for example, if you're someone has been hired for a contract, they're working from January 1st to August 15th on a certain project. They know their job is ending on the 15th of August. There's no requirement to give them notice, except perhaps maybe something in that situation changes and you as the employer, you need to cut that contract short. Then notice would be applicable. Another thing that comes to mind is someone who's possibly covered for protected leave, like maternity leave. Again, that's for a fixed period of time. The person working knows that their job is ending at a certain point. And again, no notice would apply in that circumstance. Other situations where notice would not apply would be in the construction sector. So either employee or employer in working in construction, they don't have to give notice to either party. And then, if you are terminating someone for a just cause situation, notice may not apply. And we'll talk about that here in a little bit more detail. Just click to the next slide here. So if you have a situation as an employer that you feel is a just cause termination, the employment must be ended immediately. There's been a permanent break in the relationship that just cannot be repaired. Just understand that under legislation, that threshold to show that it's a just cause situation is often considerably higher than a lot of employers think that it is. The other thing you need to realize is that if you're looking for an exception to notice based on a just cause termination, we're going to be asking you as the employer to show evidence. So the onus is going to be on you to prove that you have the evidence that you can back up your decision to show that just giving notice in this situation just simply was not possible. A lot of complexity to these investigations sometimes because the circumstances can be so very different from claim to claim. And I would say it's nearly impossible to give a fulsome answer on our general inquiry line about
Yes.
situations like this, because when a claim is filed, we're going to investigate. We're going to talk to both parties. We're going to ask for evidence. We're going to ask for records. And we're really going to look at all of the circumstances about why the employment was ended suddenly without notice. So highly individual, highly contextual. Give a couple of different examples here. So you may have someone you're having concerns with their habitual neglect of duty. Maybe there's chronic absenteeism issues. That evidence, the documentation you're going to have in that situation is going to be very different, and circumstances, of course, are going to be very different. Say if someone commits violence against a coworker in the workplace, very different circumstances, and the evidence is going to look, quite a bit different. But again, as the employer, just understand that if you're pursuing a just cause termination and a claim is filed, we're a neutral third party, but we're still going to come to you and request that you show evidence that supports this exception to notice.
If I could just maybe add a couple of
Please.
comments, because this is definitely a topic of frequent discussion
sure
with
is.
employees and employers. Things that we're going to be considering in those situations would also, we're sort of looking to go, well, what was the reason for the termination? And as Chantal said, we're asking for your evidence of that. But we're also looking to see, depending again on the context, was the individual warned? So in Chantal's example about attendance, what evidence do you have to show that you had conversations with that person and that they understood that continuing the same unwanted behavior could result in termination? So it is very, very contextual. And to Chantal, just reiterating about the general inquiry line, when we're receiving those calls, it's just a conversation with one person. So we don't have all of the pieces of the puzzle. The only time that we can actually come to a determination is when we are investigating a claim, because that's when we have all of the evidence and information from both parties.
Great, thanks, Michelle. Good point for sure.
Okay, our next topic is hours of work and overtime. Generally speaking, for most of the people who fall under the Employment Standards Code, their regular hours of work would be 8 hours in a day and 40 hours in a week. This again applies to most people. However, there are always going to be some exceptions. So one example would be someone with true management functions. They may be exempted from overtime as an example, or you might have an individual written flex time agreement in place with one of your employees. That might change what their standard hours of work would be. And then we do see differences in regular hours of work in various industries. So in landscaping during their busy season, those employees are working, as an example, up to 10 hours in a day. We also see some differences in different construction sectors as well. So in the example below, very simple. In the first example, it's pretty straightforward. The individual normally was doing 5 8-hour shifts for their 40 hours, but picked up an extra shift on the Saturday. In that case, the 8 hours from the Saturday fall into overtime. In the example below, you see that the individual worked 2 days at 8, 2 days at 6, and 1 day at 10. So their total hours for the week were 38, but only 2 of those hours exceeded the daily threshold. So that's why you're seeing the overtime hours being calculated as 2. What I want to talk about when it comes to hours and work and overtime, as employers, you have the right to manage the schedule. And that means that you are responsible for compensating your staff for the hours that they're working. Often we're hearing comments from employees that the employer is asking them to come in early. Their shift, I'm making this up, shift starts at 8. We want you to come in at 7:45 to start doing X, Y, and Z. If you are asking that employee to come in to do tasks for their work, then that is part of their work. So you need to be aware of that and make sure that you're including that time in their daily hours and paying them for that time that they are working. I also wanted to comment, we do have fact sheets because there are some other scenarios where employers may need to look at doing things differently. So we have averaging agreements and averaging permits. An agreement is when you come to the agreement with the staff. A permit is when you have to go through an application process with our office. So if that is something that you're interested in exploring for your business, then I would recommend that you review those fact sheets. And if you had questions after you've reviewed them, give our general information line a call so that we could assist. Next slide, please. Okay, so for overtime, it's paid at 1.5 times the regular wage rate. So if someone was making 12 back in the day, then their overtime wage rate, as we saw in that pay statement slide, becomes $18 an hour. With overtime, there is an expectation that the overtime should be authorized or granted by the employer. Under the code, it's also very clear that an employer, for the most part, cannot mandate overtime. It cannot be required. It should be an option to the employee, but of course, there would be exceptions in certain types of work and situations if there was an emergency. And overtime does also apply to those people who are paid through incentive pay or a commission. So there are always ways to calculate that back. We do have information on our fact sheets on the website if you were looking for some assistance, or you could also call if you would like to discuss it with one of the officers. One thing I do want to caution, just from our experience with the calls and also as we investigate claims, sometimes there does appear to be an issue of maybe implied consent to overtime. So you want to ensure that, if your employee reached out to you by text, email, saying that they wanted to stay late an extra hour, as an example, and you did not respond or speak to them about that after the event. Let's say you didn't see the message until the next day, but you never had a conversation with them saying, that was okay or that was not okay. That individual may view that as having received an implied consent. So we do want to caution employers that if you see someone, staying late and you did not ask them to stay late, you just want to make sure that it's very clear to the employee that you were not requiring them to stay to complete any tasks, just to avoid that situation. Next slide. Thank you. Oh, one thing, sorry, Chantal, I meant to go back to this. One question that we sometimes get, and it is highlighted in our fact sheet on overtime, is what are deemed to be the hours of work when calculating the overtime? So something that you need to be aware of as an employer is that the general holiday is deemed to be an hour of work for the purposes of calculating overtime. And you are not, as employers, you are not required to include vacation leave or paid sick time in the employee's hours of work when determining their entitlement to overtime wages. So I just wanted to highlight that as well.
Great point. This clarification.
Reporting to work. We also have a lot of information on this in a fact sheet on our website for those that might want to look into it further. Generally speaking, reporting pay is going to apply when you, as the employer, send staff home before the end of their scheduled shift. So if there was a situation where you notified an employee ahead of time, they hadn't arrived at work and you let them know, then no reporting pay would be required. Generally speaking, employees must be paid for 3 hours of work or the actual time that they worked, whichever is greater. So in situations where the scheduled shift was shorter than 3 hours, the employees are paid the length of their scheduled shift. And it's only the time that they actually worked that is going to go into your count for their standard hours for that week. Another thing I wanted to talk about on this topic, because we do get questions about this as well, and I'm going to reference it from the fact sheet. We get questions about schedules. And so, as most of you likely are already aware, there is no requirement under the Employment Standards Code for employers to post schedules. We sometimes get people calling and questioning how that would work. We also get questions about, can an employer have an open-ended schedule? And the answer is yes, maybe you have a situation where you don't know how long you're going to need someone to come for. The start and end are not clear. In that case, the reporting pay of 3 hours would apply. Alternatively, sometimes we know employers need to call the group together, have a special meeting. Maybe they need to have some people come in. They can't kind of get everyone at the same time. If you're telling the people, that you need to come in for 1 hour, then that is a clear start and end time, and then it would be 1 hour that would be applicable. So as employers, we often get the question of, well, do I have to make all of my shifts at least 3 hours long? And the answer to that question is no, you do not. You are the employer, you manage the schedule. If you need something to be a shorter increment, you can do that, as long as the staff are aware of what that start time and how long the shift is going to be for.
Yeah, I think probably one of the most common situations with respect to reporting pay is just like the middle photo here of all the hospitality workers
yes,
sort of standing around.
Yes,
A lot of
good
times they'll be
example.
called to work and they're
Yes.
waiting to find out if they're busy enough to start.
Right.
Just understand that the reporting pay applies once they've arrived to work.
Yes.
They're entitled to reporting pay.
Yes, absolutely. And to that point, as employers, you have the right to control the schedule. And we know sometimes operationally things happen and you do need to make adjustments. It wouldn't, make good business sense to keep 5 people if you only had enough work to support 2. So those are options that employers certainly do have. Okay, when it comes to hours of work, breaks and the day of rest, um, things for an employer to be aware of. I'm going to reference from another trusty fact sheet that we have on this topic. So, what is a break? Because sometimes we're finding there are some misunderstandings between employees and employers about what a break is. So, under our legislation, a break is when an employee is on their own time and they're free of all of their work responsibilities. So, that means that an employee technically was able to leave the workplace. So, that's a true break. We know sometimes there are situations where maybe an employer is asking someone to, could you stay at your desk? And if the phone rang, could you answer it? That would be sounding to us a little bit less like a true break. So you want to be aware of that when you're managing your staff and arranging coverage for various aspects of your business. So under our legislation, there is no requirement for employees to be paid for breaks. The legislation states that a break is, employees are entitled to a break after every 5 hours of work, but it is not required to be paid. Also, under the legislation, employees are entitled to 1 day of rest each week. Now, when we're talking about your hours and thinking about those standard hours and overtime, a question that we have in our fact sheet, which some of you might be interested in, is, are breaks included when calculating overtime? And the answer is that breaks are not included in the overtime calculations. So for example, an employee who works from 9 to 5:30 with a 30-minute break for lunch has worked an 8-hour day. So even though they're there for 8.5, they're only there, their paid time is 8 hours for the work that they're doing.
Right, thanks, Michelle. Just maybe toss in too,
Oh,
if similar
yes.
to the averaging permits and the
Yes.
averaging agreements, if employers feel like there is an undue hardship in offering, maybe you have a single employee working in your business, and that's, that's it. They're it for the whole day. And, giving them that paid break to step away and close the store would be an undue hardship. There's something called a work break order
Yes.
that employers can certainly seek out on our website. There's a fact sheet on that.
There's the fact.
And if there's any questions, we're happy to field your questions at the general inquiry line as well. We're going to talk a little bit here about vacation. So when we talk about vacation from an employment standards perspective, we're looking at 2 components. There's the vacation time that an employee is entitled to and the vacation pay that an employee is entitled to. And in both situations, employees begin to earn time and pay from their very first day of work. And this applies, Michelle mentioned it earlier, there's no differentiation between part-time, full-time, casual, young employees. All employees are eligible for time and pay. And when it comes to paying vacation wages, employers can choose to pay that out on each paycheck or accrue it in a vacation bank of sorts for when that employee takes their vacation time. And the vacation time and the pay are both tied back to the length of service. So if a person has completed 1 full year of employment with you, they're entitled to 2 weeks of vacation time. And then 4% of their gross regular wages will be set aside for their vacation pay. And then after they've completed 5 full years, that will bump up to 3 weeks of vacation time and 6% of their gross regular wages. Do keep in mind when you're calculating vacation and that is calculated on their regular earnings and general holiday pay. You're not going to be doing a vacation pay calculation based on overtime or bonuses that are not tied to performance. Something to keep in mind as employers is once your employee becomes entitled to that vacation, they've worked for that full year, they're entitled to the 2 weeks of time, you need to provide that vacation time and pay within 10 months of it being earned. So just keep that in mind. And maybe there's a situation where there's no consensus on when the employee is able to take their vacation, just can't come to agreement. Ultimately, you as the employer, you control the schedule and the hours of work. You have the final say on when vacation can be scheduled. So if you're unable to come to agreement, you as the employer decide this is when the vacation is going to be taken with at least 15 days notice. You inform the employee, and then the requirement is that they take that vacation.
I'm just going to add one thing if I could, Chantal.
Yeah.
Sometimes we're also getting questions from employees where they believe if seniority is a factor. But under our code as employers, you're likely already aware there is nothing under the Employment Standards Code for seniority. So as Chantal was saying, it's up to the employer to decide how they're allocating and providing that time to their staff.
You bet. Good point, Michelle. General holidays, stat days, stat pay, general holiday pay. The legislation refers to these as general holidays and general holiday wages. There are 8 general holidays in Manitoba at this time. You'll see the list of them here on the slide. Days that are recognized as general holidays, the employees either have this day off of work, or if they're working, they're paid 1.5 times their wage rate, so their overtime wage rate, as well as their general holiday pay calculation. As Michelle had mentioned, general holiday hours are hours worked, and they do count towards that weekly overtime threshold. When it comes to calculating vacation pay, or pardon me, general holiday wages, that's going to be 5% of the regular earned wages in the 4 weeks leading up to the holiday. And all employees are eligible for this calculation, regardless if they're part-time, if they're just casual. If they've worked in the 4 weeks before the holiday, you're going to do that 5% calculation, and that will be their general holiday pay. The exception is if they are absent without the employer's consent before or after the holiday, the first shift before or after the holiday. But do keep in mind that if the employee calls in because they're ill, that would be considered an excused absence. So the general holiday pay would still be, they would still be entitled to the general holiday pay. And if you have employees that are working on a general holiday, they are paid 1.5 times their regular wage rates or overtime wage rate. However, there are some exceptions, including 24-hour continuously operating businesses such as hospitals, hotels, that sort of thing. In those circumstances, the employer would be paying regular wages for the work done on the holiday, but then offering a different day off with that general holiday pay calculation. You notice that Remembrance Day was not indicated to be a general holiday, and that's because Remembrance Day has its very own separate piece of legislation under the Employment Standards Code. There's some similarities to the general holiday piece, but most industries are not permitted to operate on Remembrance Day. Again, there are some exceptions: hospitals, hotels, restaurants, continuously operating businesses, that sort of thing. If staff don't work, unlike general holidays, there's no requirement, there's no calculation, they don't get anything for not working. If they work, then they're required to be paid their overtime wage rate and for at least half of their regular hours. So if they normally work 8 hours, but they work 3 hours on Remembrance Day, under legislation, they're entitled to be paid for at least 4 hours.
Okay, our next topic are leaves of absence. So under the legislation, there are a number of leaves that are available to allow employees with time that they need to deal with certain things that occur in life without fearing for loss of their job. So the things that employers must be aware of under the legislation is that employers must provide the employee with the time off of work for the leave that they're requesting. And they also must allow that employee to return to the job that they held prior to taking the leave once the leave has come to an end. Now, we also know as things can happen to employees, things can also happen to employers. So there could be circumstances that arise where that person's job is no longer available. Generally speaking, then the expectation is that the employer would provide that employee with a similar position that had similar or greater benefits and pay to the position that they were unable to return to. There are also, though, sometimes circumstances where an employer is not able to bring someone back. Maybe a position has been eliminated because of other issues in the workplace. And so, should that happen, the onus will be on the employer to show that the individual's decision to take that leave had no impact on the employer's decision to lay them off or to terminate the employment. We talked a little bit early near the beginning about how, the majority of the leaves are beg your pardon, the majority of the issues that we're investigating are related to the payment of wages. But we do have investigations happening for potential violations of protected leaves. So that latter point about employers being able to show that their decision had nothing to do with the person taking a leave, should there be an investigation, that's when that evidence would become very important. Under our legislation, the majority of the leaves are not paid. They are unpaid leaves. However, oftentimes employees are able to reach out to employment insurance and apply for benefits depending on how long they're going to be away for. Uh, for all of the leaves that we're going to talk about, there are various things that are in place in terms of how does someone qualify for the leave. So generally speaking, employees have to have worked at least 30 days, but as you'll see in the coming slides, for certain types of leaves, that length of qualifying period will vary. The other thing employers need to be aware of is that employees are supposed to notify the employer of their request for that protected leave. And the definition of family is often something that could come up for debate. Under the legislation, we view it very broadly. So that could be the traditional elements, so a spouse, common law partner, children, stepchildren, parents, grandparents, etc. But you also note on that last bullet point that we say anyone that is not related, but whom the employee considers to be like a close relative. So that's important for employers to be aware of, that it is a very broad definition. The other piece is that you as an employer, you don't control when the employee can take a leave that's available to them, that they've met the qualifying period and they're entitled to. So example, I'm going to give just a hypothetical. So if someone notified you that they were taking bereavement leave starting the next day, you couldn't say, well, you know what, I'd prefer that you start your bereavement leave next week. It's the employee who's essentially initiating the request for that leave. And as the employer, you have to respect the timelines that are being presented. So on this first slide, we're kind of talking about the most common leaves that we get calls and questions about. I won't go into each one, but you'll note that the type of leave, qualifying period, and the length of the leave and the reason for the leave are, of course, all going to be different. One thing I do want to highlight to employers, family leave, which is the leave that is for an employee to deal with a family responsibility or their own personal illness. With that type of leave, employers are not allowed to request a medical note. And that length of the leave is 3 days per calendar year. Now, with all of these lengths of leaves, we also acknowledge that many employers do provide their employees with a greater benefit. So while it's not required under the code, this is giving you the minimums, but certainly if you're an employer who's choosing to offer additional time, nothing wrong with that. That's an acceptable practice. This second slide just highlights some of the other leaves. These are leaves that we don't get as many calls or questions about, but as employers, of course, it's just important that you're aware that there are different types of leaves that are available under the legislation. And so should you receive a request from an employee, feel free to give us a call or to access the fact sheets on our website and if you needed assistance in working through any particular type of leave.
Great, thanks, Michelle. Yeah, definitely lots of good information there. Talk here a little bit about employment of young people. So perhaps you're an employer that employs folks that are under 18 or under 16. Just realize that the legislation varies a little bit with respect to the employment of young workers. If there's an employee who's under 16 years of age, they're required to have completed the Young Workers Readiness Certificate course prior to them starting work, and that's in conjunction with Safe Manitoba. That's an online course, and you'll see on the slide here. There's some rules to them. People under 18 that are working, under 16 they cannot work at all between 11 p.m. and 6 a.m. and are limited to working 20 hours a week during the school week. And you'll get to this on the next slide, but they're prohibited from working in some industries. Under 18, they don't have to complete the Young Workers Readiness Certificate course, and they can work between 11 and 6, but just not alone. But there's no limit to the number of hours that these employees can work. And again, some limitations apply. Big point at the bottom here is that anyone younger than 13 years of age is not legally allowed to be employed in Manitoba. And then with respect to some of the prohibited industries, I'd like to think that a lot of these are common sense, but for the sake of legislation, it is spelled out here. So things like, folks under 16 working on a construction site, or, imagining them washing windows on a swing stage, not a great idea. They're also not permitted to work without adult supervision. That's probably a really applicable rule. And then anyone under 18, again, some other limitations. So not in confined spaces or open pit quarries. And then again, not alone between 11 p.m. and 6 a.m. And I think that brings us to the end of our presentation. So
I just wanted to say thank you so much to those who were able to join us today. We really appreciate this opportunity to be able to offer some education and hopefully to clear some things up. And reminders that our general information line, as Chantal said, is available Monday to Friday. And we have a ton of resources on our website, which is the employment standards. The link there to the site is listed. So I guess we'll turn things over to Eric if there are any questions.
Okay, so I'm just going to read a couple questions in the chat here. So we had a question from Shelby. She said, can pay be withheld until a company uniform is returned?
The answer is no. So we know that does sometimes happen. Employers, I haven't had one about a uniform, but I've had one about equipment. Employers sometimes believe that they can hold back the pay until they've received the return of the items. But under our legislation, it's quite clear that all earned wages have to be paid without any holdbacks within the time periods that we discussed earlier. So sometimes those, in our experience, sometimes it's just a misunderstanding where an employer may think they do have the right to do something, but that particular situation, the answer is no.
Okay. So a question from John here. Can you speak to the quality of work in a working notice? If they call in sick, they forfeit that day's pay right. And what about any potential sabotage? If you feel that may happen, just pay them out.
Go ahead.
Yeah, well, I would, apologies if I misunderstood the start of the question, but yes, under the legislation, because the employers have the right to terminate at any time for any reason, as long as notice is provided, it's really up to that employer to decide, do they want the working notice, or would it just be less stressful, straightforward to just issue the payment of the wage in lieu? So if an employer chooses to do so, that's fine, but working notice can be part of it. You can do a combination of like one, the other, or a combination of the two, as long as you're following that notice period, depending upon the person's length of employment with the business. I'm not sure if that answered the question or not.
Could I just a quick follow-up if you don't mind?
Yep.
Yeah, of course.
So just in that working notice, I don't want to seem like malicious or anything, but we don't know people. Some people change, they build resentment. What if there is something where they're potentially stealing your client because they have a technical skill set and they're talking to the customer directly? during payment saying, why don't you come to me next time because I'm doing this on the side? Is there anything that is justified for not paying them out because of their working notice not being, not having integrity, not having points of maybe risk to damaging a project or something? You just don't know how someone might change. I don't know, like.
Fair enough. No, that's a question. That's a situation. We've had several claims lately with respect to that pretty similar situation. Ultimately, that becomes a business decision for the employer. You have the right to decide if this is, is it going to be problematic having this person work out their notice? If so, you can certainly decide to terminate them immediately, but that notice period is still going to apply. So if you're not offering
Okay.
working notice, then wages in lieu of notice needs to be offered, because as I said, it's ultimately a business decision. That's not defined in the legislation. You're free to make that choice as the employer. We certainly understand why there might be some proprietary information, client lists, depending on the industry, that would be sensitive, and you don't want them walking out the door with your employee. But ultimately, you as the employer need to make that call and decide whether you're going to provide wages in lieu of notice or you're going to offer that working notice.
And regardless, there would be nothing in that situation that the employee could really do during their working notice that would forfeit their pay.
No, not necessarily. I mean, it depends. Is a great
that's
answer.
Our standard answer.
Situation like this. I think you mentioned at the beginning of the questions, the word was sabotage that was used. If you're in a working notice situation and the employee's quality of work, their actions in the workplace, they don't align with what their typical duties are, again, we're a neutral third party. So if you ultimately end up terminating that employee because of the circumstances that are unfolding after working notice is offered, keep your evidence, right? Because if they end up filing a claim stating that they were terminated and they were entitled to wages in lieu of notice, as a neutral third party, we're coming to you as the employer, and we're going to say, hey, employer, show us what you're describing. Show us that this person was sabotaging or was coming in 2 hours late or being disruptive in the workplace. So certainly circumstances can change, and there might be reasons for you to do a just cause termination. You just need to have that evidence to back up and to show the situation, so that if a claim is filed, you can present that to the officer.
Okay, thank you.
You're welcome. Good question.
So we also had a question from Hernan. So can the hours be less if agreed with the employees? Example, 35 hours a week.
Yeah, I mean, you can decide on whatever number of hours you want to offer the employee.
So the employer, we talked a little bit about it earlier, right? So you as the employer control the schedule. So if you want someone to come in 2 days a week for only 5 hours on each of those shifts, that's okay. There is no, when you're hiring someone, you're not obligated to provide them with 8-hour day, 40-hour week. And so the employer manages the schedule, and just you need to know what those thresholds are if something would tip you over into an overtime situation. And then as Chantal was talking about earlier with vacation wage, general holiday wage, those things are all being calculated based on whatever that employee's actual hours worked were.
And note too, like as the employer, because you are in control of the schedule and hours of work, maybe your operational needs change. Maybe you've hired someone as full-time.
Yes.
Situation has changed. You need to reduce their hours or their work days. You are in control of the schedule and hours of work. We would suggest that you provide as much notice as is reasonable given the circumstances, but you are in control of those aspects of the employer-employee relationship. So you certainly can change the number of hours that you're offering to a particular employee, even, taking someone from part-time down to full-time, vice versa. It's all within your control as the employer.
Perfect. Susan had a question here. So can you give details on flex time agreements?
So a flex time agreement is a written agreement between an employer and employee, and it's to deviate from the standard 8 and 40, but it cannot go above 10 hours in a day. So the common situations that we've seen is maybe in a certain type of business, an employee, generally I think they're employee initiated, an employee would maybe for perhaps a childcare reason, wants to change their hours of work. So maybe they're going to do 2 longer days, 2 10-hour days, 2 8-hour days, And then on their 5th day in the work week, they're going to do a 4-hour day, or however it works out to being that 40 hours. What that does is it allows the employer, there's no requirement to pay the overtime on the days where it's 10 hours instead of the standard 8. And we do have I'm not sure who asked the question, but we do have a fact sheet specific on flex time agreements available on our website. And I believe there might also be a sample template, so that individual, if they wanted to take a look at that or give us a call on the general information line, we could probably provide some more specific assistance, because there are some governing rules around, what that hours, what it could look like, how many hours it has to be in the week, etc., things of that nature.
Perfect. I know we're a little bit over time here, so if some people need to go, go ahead. But I'll wrap up with a couple more questions here. So there was this one with Robert. So what does an employee get for stat days if their agreement is to work 4 days per week, Monday to Thursday, 32 hours?
Well, it's really going to depend on what that schedule looks like when a general holiday rolls around. So if you are working on the general holiday, you're entitled to be paid for all hours of work at the overtime wage rate. If you're not working on the general holiday, we would be looking at the general holiday wage calculation being performed based on the 28 days prior to the general holiday. Hopefully that answers the question.
So everyone under our legislation, if you're covered under the Employment Standards Code, you have an entitlement to general holiday wage. There are a few little exceptions where there are certain circumstances where it may not apply, but most of the time, everyone is entitled to receive that general holiday wage, and it's just the percentage is based on whatever their earnings were, as Chantal said, in that 4-week, 28-day prior to the holiday. So you should still be receiving that percentage.
Okay. And Evelyn here says, is a notice required if it is a retirement? Is age a factor to consider too?
I'm not sure if that question is like if an employee is choosing to end their employment? Is that the question, or is this an employer wondering if when someone reaches a certain age, they have to terminate them?
Evelyn, do you want to unmute and elaborate on that question here? Is Evelyn still in the chat? Oh, yeah,
yes.
there she is.
The question is related to someone who has reached the age of 65, for example, and wants to retire, and vice versa for someone who is not aged the age of retirement as well, both sides.
So, I mean, if the employee is initiating any end of the employment,
Yes.
then, the legislation does stipulate that there's a notice period required if the employee is giving notice. Pardon me. I would think in a retirement situation, they would be looking at, based on their length of service, likely would be looking at the 2-week notice period. But circumstances, because it's employee initiated, there's no requirement to pay wages in lieu of notice. The employee is just required under legislation to provide working notice that their job is going to be ending for some reason, retirement or otherwise.
And as Chantal said earlier, the maximum for an employee is 2 weeks. So regardless if someone had been with your business for 10 years, they would still only need to provide that 2-week notice under the legislation.
Okay, so I'm going to wrap up with this last question here from Leah. If the employee doesn't take vacation, do they have to have their vacation paid out to them?
Right, that's a good question. So as I mentioned when we talked through the vacation slide, as the employer, it's important to realize that the vacation time and the vacation pay both need to be provided to the employee within 10 months of them earning it. And that can be where, the employer requests vacation time, they get the pay while they're off, or if there's no consensus, you as the employer decide this is when the vacation is being taken, and the person is, put them on vacation, you pay them for their vacation wages. But yeah, it would be 10 months from the time that it has been earned. You need to be providing that vacation time and pay.
Good question. So I just put in the chat here. We're going to wrap it up here. So Before everybody leaves, I just want to mention or highlight that our next webinar coming up next week, it is Choosing the Right International Market, hosted by Victoria Uman and Ivanka Watkin. So I've included that in the chat as well as my contact information, so feel free to reach out. Again, thank you, Michelle and Chantal, for this great insight, and everyone for attending this webinar. So again, if you have any more questions, feel free to reach out to me, myself, or Chantal, or Michelle. And then, yeah, everybody, I hope you guys have a great day. And yeah, I can't answer all the questions here because we'll be going for another 20, 15 minutes. But if you have any more questions, you can always email Chantal and Michelle. Their email is I believe on the slides. So you guys can always reach out to them that way.
Great. Thanks very much, Eric.
Thank
And
you.
thanks everyone for attending. We appreciate it.
Okay.
Okay.
Bye, guys.